Do you have spousal consent? Actual spousal consent. Okay. The larger the company, when you start getting into the millions of dollars, we recommend the spouse have his or her own attorney. Okay, because we don't want to be there and say, so one of the first questions we ask when we sit down with a prospective client is, who do we represent? Are we representing you, or are we representing the business? And that's a critical question for attorneys, because if we represent the business, and we're about 50-50 on this actually, if we represent the business and there's a dispute amongst the partners, we're on the sidelines. Why? Because we're privy to all their confidential information. I can't use one person's information against them by representing his or her business partner. Okay? So if we represent an individual, then we make sure that the other business partners sign a consent. Our consent has some language in there that you understand that we can sue you. It does. They need to understand that the bar requires me to do that. Otherwise, the first motion they file in court is exclude this guy. Okay, so this way we go, Judge, here's the rules. Rules require this to be in writing. Here's the waiver. Here's the consent. Okay, that they understand I am not your lawyer. Okay, if you want to have something, you want to share something with me, don't. We can go have a beer, we can have dinner, that's fine. But do not share information with me and expect me not to use it against you if I have to sue you. In fact, our firm, in a major piece of litigation, they try to bring us in saying, oh, you're aligned with the business owner, and they promised me shares, and, I talked to these lawyers, and so, you're my lawyer. And we said no. And the courts have said no. Okay, so we're very picky on that issue. Who do we represent? So going back to the issue of divorce, that's important, because if we have to create documents, such as a prenup or something like that, then it's very important that we represent one of the spouses, not both. Okay? We talked about community property, and here's why the community property is so important, because with community property, each member of that community has 3 distinct rights. They can manage, they can control, and they can dispose. Okay? Manage, control, and dispose of community property assets. So we talked about spousal consent. It can be as short as that. Typically ours is a lot more detailed and would require information from the attorney that prepared it. But just for your information and for your clients, or if you're a business owner, that's typically what we have. Right? Prenuptial and postnuptial agreements. I don't want to steal anyone else's thunder, but it's very important that these agreements work together. It's important that your company agreements work with your insurance agreements, with your wills. It's important that what you do makes sense to your CPA, okay? And your bankers probably also need information to make sure that the products that you deal with are within the protective framework. Post-nuptial agreements are tough, okay? They're tough to execute. And I kind of tell this, when clients come to us and say, well, I want a post-nuptial agreement done, kind of scratch my head and says, how are you going to start this conversation with your spouse? We've been married for 10 years, and you want to sign something saying that, by the way, you don't have an interest in this company? I can't help you on that. Good luck. Okay? Prenuptial agreements are equally difficult, because a prenuptial agreement must be the result of non-coercion, or they cannot be the result of coercion. So here's what Texas courts have looked at, and this is for business owners. Okay, these issues typically don't come up when you're talking about individuals. They come up when you're dealing with high net worth folks and business owners. Here's what a prenup challenge looks like. Okay, couple files for divorce. One party says company's mine. Here's a prenup. Other side argues, this is not a valid contract. It was coerced. Court says, how is it coerced? What are the rules for coercion under Texas law? Here's some of the rules that you have. Was that prenup drafted after the wedding date was set? Oops. Coercion. Why? Because it's an embarrassment. What are you going to do? Cancel your wedding date? The option is sign this or we don't get married. Were the invitations sent out? Was any action taken in furtherance of the wedding? Okay, what we not the legal wedding necessarily, but what we construe as getting family and friends together, that someone was basically not given a choice as to whether they need to sign this or not. If any of those circumstances exist, a court will set aside that prenup. Anyone in here use a mag light, the flashlight? Yeah? You're familiar with it? Very famous case. Mr. Maglica came up with a mag light, and in the late 70s, he went through a nasty divorce. His company was growing, and that divorce probably cost him about $16 or so million. Okay? Fine, got it done, cut a big check, went out. Maglite became a billion-dollar company. By that time, he started having an affair with his administrator. Okay? And he got her to sign something saying, I want you to move in with me, but I want you to sign something that you acknowledge we are not married. We're consenting adults, we're living together and all that other good stuff, but we are not married. They lived together for several years, 15, 20 years, at which point Maglica decided to not continue. She sued him in family law court. He goes, what are you talking about? We're not married. Ah, common law marriage. Okay? And says, well, even if that's a case, which it isn't, you signed this agreement. Right? She said, you coerced me. Okay? Went to a jury trial, family law court. His administrator is now a very, very, very wealthy woman. Judge set it aside. Okay? Disability, another big D. I hate this provision. Okay? This is a provision that clients come in and they say, I have this provision in the contract, what is, can we enforce it? I say, I don't know what it means. What does it mean today on a disability clause? Because you have insurance companies that have a short-term versus long-term disability. You have a spectrum of loss of ability. And you have a strict insurer's definition. Which one do you use? Okay, so if you're using this type of provision in your agreement, what are you tying it to? What is the matrix upon which you view a person's quote-unquote disability? Okay? You have a Code of Federal Regulations that defines what disability is. Okay? Physical and mental impairment, which has lasted a certain amount of time. Well, and then you have the substantial gainful activity provision. And so with the Americans with Disabilities Act then defines disability. Okay? What does this mean? If you have a physical impairment, does it mean that you cannot continue the business? And why is this important? Because remember we talked about a closely held company, that you're actually working there and owning it? If you do both and one of your partners says you're disabled, you can't function, you can say, well, if you have mental acuity, you can function. Major life activity, I'm not going to read the statute, but it's the inability to perform a single particular job does not constitute a substantial impairment in a major life activity of working. And that's in this circuit, the Fifth Circuit in which Texas is. Okay? So this issue went all the way up to federal court. Federal court says, looking at federal law, that doesn't qualify. So that means you don't get to buy that provision out. So let me just be clear on why this is important. So this is how it plays out. One partner says, I'm entitled to buy your interest out. Other guy goes, the heck you are. Says, oh, you're disabled. Okay? And as a result, we get to buy it out. And if you think this is fiction, we just had, when did we have the case, Joseph? July?
I think June.
June. Real estate company. Doing extremely well. Two partners went at it. There's a provision in the agreement that's drafted by counsel, who's now in a lawsuit because of what he drafted, that stated that if you have a disability, and he defined disability in there, then there's a shotgun buyout clause. Okay, which means the other partner gets to buy them out. So both sides try to buy each other out. So they went in there, one side alleging breach of fiduciary duty, this other side alleging the same. We went in there, and during the course of arbitration, we learned that this other partner was taking a certain type of psychotropic medication. Very benign. Okay? But she had an event that lasted no more than a few weeks. Okay? But that event, without going into too much detail, that event constituted a disability under our interpretation of the agreement. So we pushed that, and the other side said, oh, they're nuts, they're trying to steal the company. At the end of the day, it's what the arbitrator decided. And the arbitrator held in our favor. So we got to buy her out. Okay? Those provisions, that's an unfair situation, but my job is not to be fair or not. My job is to represent my client. Okay? So, divestiture, this is another issue we face when you're running into financing or you have a third party's interest in your equity in the company. That happens by judgment, sale, bankruptcy, any other provision in which you hypothecate interest to a bank, whatever it is. If you provide for that in the agreement, it triggers a buyback provision. Okay? So divestiture is broken up into two major areas: affirmative acts, sale, transfer, hypothecation, any attempt to alienate your interest, or as a consequence of something, death, disability, and divorce. So by the way, guys, part of what we're talking about here, part of why the session is important to you and your clients, focuses on this part. What do you do when there's a consequence? How do you mitigate that? How do you keep the company going even if this occurs? So, death, descent, and distribution. Here are a couple of things that we recommend that companies need to have at a certain level. Okay? So what used to be called a key man insurance policy, which is the life insurance policy, and our insurance guys will talk about it more, financial planners will, dealing with the reality of the company agreement, okay? Interaction between the company agreement and the last will and testament. This is very important. Why? We don't want the company to go through probate. A probate judge, God bless them, they are not qualified to handle how major companies operate. I'm talking about major privately held companies, okay? Because they're looking at the probate code, which is very specific as to what happens. And should you pass without a will, then you better have a company agreement to keep that out of probate. The problems that we face, again, we're called into family law court, and we hate family law court, okay? It's just way too much drama that we don't want to deal with, but, you know, it pays. Probate court's the other end. We get dragged in because no one knows what they're doing. Okay, what do we do with the company? Okay, there was a great commercial, maybe it's a New York Life commercial, David. It's like, it stuck with me because the commercial goes, there's a gentleman who's standing overlooking, you know, the skyline of a major city. He's probably in his 60s. And he's reminiscing about his business partner, saying, you know, we've been partners for 40 years. You know, and last week he had a stroke and he died. I was shocked. And then it says, more shocking was the fact that this morning I learned that I am now partners with his 24-year-old son. Okay? So what do? Okay, and that happens. We deal with those issues. That's right now here in San Antonio, Texas. It happens. How do you mitigate that? The company agreement must dovetail with what the wills are. And here's why, if there's a reason for you or your clients to say don't use a form agreement, okay, because an agreement's an agreement. You have all these different documents that must work together. If they don't work together, number one, if you're providing that type of advice, just stepping out of, take a quick tangent here. Other cases we're dealing with, right now we've got a case against an individual, licensed professional, who purported to advise clients on how these agreements work. Okay? So basically, that's part of the real estate deal and part of the reason we're suing. It says, what business did you have doing that? Because the advice you provided was wrong. So what happens if you provide the advice and you're not an attorney? You can't go to a court and say, Judge, I didn't know. I'm not a lawyer. You provided advice. You're held to the same standard that an attorney would be. Okay? So that means call your insurance carrier and hopefully it's covered. Okay? What does the insurance carrier do? It says you are acting outside the scope of your E&O. Okay? I can't, when clients come to us and they start talking about taxes, what do we say? We are not providing you tax advice. Go to your CPA. Okay, because that's not covered in our E&O policy. Okay, if you're there as a investment advisor, financial advisor, if you're there as an accountant, whatever it is, stick to your scope. Okay, when you're talking to people who have money, the moment something goes wrong, I will guarantee this, keeps us in business, they're looking for someone to mitigate that damage. You don't want to be a target. This is in our handout, the effect of not having a will with intestacy. Again, I'll send this to you. I don't want to go through it. But it is different if you have a will or if you die without a will. Okay, if you die without a will, you have no choice in how your assets are passed on. You're subject to the probate code. Okay, and the reason I skipped over that is for time, but if you guys were here the last time I presented this, Seth explained that, and I took about 10 minutes, and I was like, what the heck, what happens now and then? Says, you don't want to explain that. Avoid it.
I don't know if he had me explain it because I'm so good at explaining and could clarify it, or because I can't explain it clearly enough in a short span to give the idea that you do not want to go through probate through.
Yeah. So buybacks and buyouts, and then the answer is both, really. You know, the buyback and buyout structures. Last year, a case came out, and I've talked about this. The first time I gave this presentation was the end of last summer. This decision came out, and it was huge. It basically gutted a lot of liability that a majority holder has. Okay, and I told you guys at that time, if you were here for this session, I agreed with the Supreme Court here, because what the Supreme Court said, remember, we're a pro-contract state, it says if you guys sign that document, we're going to hold you to that document. Because prior to this decision on June 20th of 2014, if you were a majority equity owner in a company, okay, if you were a majority equity owner, then the court said you owed a duty to the minority shareholders or the minority partners not to do anything that would hurt them, right? So it didn't matter what the agreement said. You can say, oh, you know what, the agreement says this, but you know, you still were unfair to me, and you have a lawsuit, right? And we said, okay, if you didn't read the agreement, your fault. Why are you looking at a shareholder agreement different than other contracts in the state of Texas? It just didn't make sense to me. Okay, so that was a battle we always fought. And then the Supreme Court said, here's what they said: we are equally reluctant to permit courts to interfere with the freely negotiated terms of a private contract or to insert into such a contract rights or obligations that the parties could have bargained for, but did not. The Texas Supreme Court is telling all the other courts in this state, if they signed it, they own it. If it was a form, if it was whatever it was, if they signed it, they own it, and we believe that they negotiated these terms, and we're not going to mess with it. We talked about a drag-along rights and tag-along rights. So a drag-along right occurs. We're moving into phase 3. What happens if you get an offer? Okay, one shareholder gets an offer to buy his or her interest, and it's a nice offer. And the other shareholder didn't get the offer. Says, wait, what about me? Okay, a drag-along right is something that's negotiated. Typically, it occurs when there's an offer to buy less, but not less than all. That means it's less than all of the shares in a corporation, okay, or an LLC, whatever entity it is. And so you're buying part of it. So they say, I just want to buy 30%. Okay, the other shareholders are going, man, that's a lot of money. Why can't I share in that, in the wealth? What the drag-along right allows them to do is to do that, where the contract says, if you get this offer from someone who can pay for it, then we get to share in it on a pro rata basis. Does that make sense? Okay. So basically, you want to structure the provision to make sure everyone shares in that wealth, if they agree to it. Okay. Sometimes some people will say, no, I funded this company, I started it, I provided the intellectual capital, and guess what? I'm going to be the first one to check out, and you guys don't share in that. Okay, or if you give employees stock in the company, they'll say, you don't get that same right. So again, this is a negotiated provision. Tag-along rights, same thing. This is a provision in which you can't have one holdout. So typically when you have a successful company that's going to be bought out, someone's coming in and says, I want to buy out the company. I want all the stock, right? And you have a minority shareholder, maybe holds 10%, says, no, I'm not willing to sell. The buyer goes, it's all or none, guys. If I don't get 100% of it, I'm not putting $1 on the table. Well, with a tag-along right, when you have an offer to purchase the company, okay? Oh, I'm sorry, I kind of got this backwards. There's a tag-along, right, was the first one I talked about where you get a tag-along. The drag-along is, it doesn't matter if you object, you get to go along with the deal, okay? Does that make sense? Drag along, if you object, too bad, we're going to drag you along. If you have a nice offer and you're excluded, you want to tag along. And this is done by an option contract. So we talked about a buyback provision. Who's going to buy it back? The company? Another individual? How's that going to happen? And what's the strike price? How are you going to value your company? Is it going to be off your books? Or are you going to have a third party come and value it? How's that realistically going to work? There are various ways to structure a buyout. Here's some proposals I put out there. You guys decide. At the end of the day, it's something that you must decide. Okay. We talked, the final phase of this is fiduciary duty, litigation, and I'll go through this very quickly. This is the litigation side. This is what happens when partners sue each other because they think one person did something that they shouldn't have done. So let me start off by saying these are some actual quotes from lawsuits that we've been involved in, okay, that have been filed with the district court, public documents, okay? Brother against brothers. This is a business that has been around since '69, okay? And then we took down that business last year, okay? These guys, basically their grandkids fostered this disagreement. This was filed in a court, one brother against another. Through the good graces and good fortune of older brother, second brother, and third brother, immigrated from Greece to America in 1969 to join older brother in his business in Texas. Second brother and third brother's situations in Greece was desperate. Okay? Third brother's very underwear was made of sewn together pieces of U.S. aid food sacks. That's how bad it was. At the time that we filed the suit, these guys had over $100 million in assets. Okay? So this business was taken down because of ego, grandkids, and they did not have an agreement except a form document which no one knew what it said. But this is what they were saying about each other. And these guys were, what, in their 80s? In their 80s. Okay? Now, here's another thing. This is a father suing a son. Oil and gas business grew from $500,000 to a little over $30 million. They get to a point where dad got divorced. He had a extramarital affair in Russia. And so lawsuits were filed. These are allegations that were made in a public filing. A cursory review of former business partner / dad's efforts to treat the corporation as his personal ATM necessarily provides context to this dispute. In 2007, Dad vacationed in Russia where he met a paramour who he agreed to provide for using company money. Dad created a false lease agreement for space in Russia and bought a car in Russia using company monies. Wouldn't you like to be there for Thanksgiving Day, dinner there? Okay. Even talking about professionals. This is a lawsuit we have that's ongoing. Okay. Lawyers acting improperly, big surprise. Here's a quote in this ongoing lawsuit that we have right now. Once former law partner began to work, it became evident that former law partner had misrepresented his work experience. Former law partner was not capable of preparing even the most basic of written correspondence. When confronted about his inability, former law partner called law partner, the other party, an uppity whatever. Former law partner used company funds to pay for strip club outings and sexually harassed female employees, including requesting sex for favorable treatment. Okay? These are things that are filed today in a suit from a law firm that we've taken apart. Because it doesn't matter how sophisticated you are. The number one issue is when people start to fight, it's not when a company is starting. I'll tell you that. When companies are just starting, they want to work together. They want to make it happen. It's when the money starts coming in and the egos get out of control that you have this kind of stuff happen. Okay? And this law firm didn't have a solid company agreement. Fiduciary duty is basically a duty of loyalty and care and obedience. It results from a relationship of trust and confidence and an obligation to put the company's interest before your own. Okay? So the typical individuals who own a fiduciary duty: officers, directors, partners, managers, high-level employees, attorneys, agents, trustees, and executors. Okay, let me just go through this really quickly. We put in here, It Takes a Titan. That's a company that we have that provides accounting and legal services to companies that are growing. But these areas need to be consistent, not just for legal purposes, but when you're dealing with Homeland Security, when you're dealing with the IRS, you want to make sure you have a consistent deliverable. Mr. Almanza will be talking about the accounting aspects of dealing with Titan and having this coordinated, and I think that'll be helpful to many of your clients. Same thing, and I'll just wind up by saying, when your clients need money, okay, be really careful about dealing with venture capitalists. Okay, I'm not saying they're all bad, but typically in our experience, we tell people dealing with a venture capitalist is like giving them your left hand